Few sentences have been quoted more often than the aphorism. Justice must not only be done, but must also be seen to be done. This dictum was laid down by Lord Hewart, the then Lord Chief Justice of England, in the case of Rex versus Sussex Justices 1924 1 KB 256. But I was a live witness in Bombay High Court when justice got butchered in an open court by a particular judge. Then I literally felt ashamed of myself and then felt that who will save the affected with this kind of judges and with this kind of justice system. Friends, it was COVID-19 time, particularly the period of September 2021. Courts have been working on hybrid system. Standard operating procedures are very much in place. Only urgent matters have to be taken on board. Matters of exception in nature are allowed for hearing, mentioning. But the stage here is the court of the then judge, Justice Sandeep Kashinath Shinde. With all due respect to the land judge, what I would like to say is the judge has taken the case which was not there on his board in the first instance, and the counsel representing the accused cum the writ petitioners was Mr. Haresh Jagtiani with a battery of trainee lawyers and juniors, and when the other side were just following the standard operating procedure of not exceeding 2 members of any particular side. The counsel and one advocate were representing the complainant cum respondents in writ petition in front of the court or from legal firm Lex India Juris. Whereas the counsel representing the accused cum the writ petitioners and the counsel who went out of the way during COVID time and got the matter onto the board, though it was not part of the board, was Mr. Haresh Jagtiani of Oasis Counsel, or sometimes he also calls Haresh Jagtiani and Associates. I was live witness to the proceedings in the court, so I can testify anytime in front of anybody if need be. What was the case? The case was that the trial court issued process on accused, and accused do not want to attend trial court, and accused have filed a revision petition in sessions court which was dismissed by the sessions court, and then accused, by taking the rescue of section 482 under article 227, again tapped the high court route, stating that they have some evidence, and if that evidence is perused by high court, then the accused will go scot-free and there won't be any case on them. This is what the precise contention of the land counsel for the accused cum writ petitioners in the writ petition. The writ petition was of 2018. It was mentioned in front of several judges, but the senior counsel could not succeed in convincing the judges on the necessity for staying the proceedings. But he has tapped the COVID-19 restricted functioning of the courts as an opportunity and utilized that period to somehow get the case onto the board, out of the way. And surprisingly, the way the proceedings took place makes us feel that the law got butchered, the justice got butchered. As it was mentioned, the case has passed through several judges. In a sequence, if we see the kind of orders passed by the various judges, the first judge on 4th September 2019 has passed an order stating that there is a consensus between the learned senior counsel appearing for the petitioners and learned counsel appearing for the respondents that the matter can be argued finally at the admission stage. Accordingly, matter is argued at length by the learned senior counsel appearing for the petitioner, part heard, to be heard on 5th September 2019 at 4 p.m. This is what the first order. In the first order, it was the consensus understanding between both the counsels that the matter can be argued finally at the admission stage itself, and arguments were started, arguments progressed. Meanwhile, the judge hearing the case as on September 2019 got promoted to the division bench, so the hearing ended over there. After that, when it went to another judge, he also passed an order stating that it is seen that on last few occasions, elaborate hearing of the matter took place before this court, In view of this, the land councils appearing for the parties submit that as the matter requires consideration, it be posted on a suitable date so that it can be heard. So, a date was given again with the order of the necessity for the matter to be heard at the admission stage. Whereas the second order was of 11th February 2020, and from then the COVID period started and the COVID protocols were in existence, courts were functioning in hybrid system, and suddenly the senior counsel and the writ petitioner for the accused found a convenient way for him to get the case listed onto the board, though it was not there on the board. And on that day, the judge was Justice Sandeep Kashinath Shinde. The matter was called at 1:25 p.m., just 5 minutes before the lunchtime, as lunchtime starts at 1:30 p.m. and the accused cum writ petitioner's counsel stands and fumble some irrelevant issues which are not part of his writ petition and seeks stay of lower court proceedings. Then the judge looks at the complainant counsel, and the complainant counsel in brief states that the writ petition was filed under section 482 article 227 and that unless the matter is heard and considered, no stay can be granted. And then the counsel for complainant says that no stay in pre-trial cases can be granted as per the precedents of the Supreme Court, and also that where there is no exceptional issue and that the current case which the accused counsel has mentioned doesn't fit for stay because it does not come under an exceptional case. And also the counsel for complainants and respondents said that two judges already ordered and heard matter substantially, hence a hearing date may be fixed and matter be heard accordingly and disposed at the admission stage itself. Whereas all this has happened in a jiffy, in the sense that stay request from the accused cum writ petitioner's counsel and the preliminary objections from the complainant's counsel, all that have happened in a jiffy, and then the judge did not open the case file, did not allow either the counsel for the accused or the counsel for the complainants to open the file. But the counsel for the writ petitioner cum accused and his galaxy of trainees who defied the standard operating procedure by entering the court in big numbers were showcasing some files and papers in the air. The counsel for complainant wants to open the file and get into detailed argument. At the same time, court staff were banging the doors for lunch break closed off the court. At that point of time, the learned judge dramatically closes his eyes for a while and whispers in the ears of his assistant and says, "Trial court order is dismissed." And then he stands and leaves the court. The accused side lawyers were jumping, dancing, as they succeeded in the matter without even opening the files, without even opening the brief. And as they were struggling even to convince the erstwhile judges on this matter, and the judge, Justice Sandeep Kashinath Shinde, without letting the counsels open the files or without he himself opening the file or reading, he just said, "The trial court proceedings are dismissed." And surprisingly, after 2 days, the staff of the court uploaded an order delivered by the judge, and it was altogether different to what he has pronounced in the open court. This is the order of Justice Sandeep Kashinath Shinde, delivered on 17 September 2021. He says, "PC, admit, hearing is expedited. Pending admission, there shall be interim order in terms of prayer clause B. Add the petition in the final hearing board in the week commencing from 22nd November 2021. This is what the order he has passed. One side, he says admit. The other side, he says hearing is expedited. Again, he says pending admission, there shall be interim order. Okay. In terms of prayer clause B. In the first instance, he has contradicted his open court order of dismissing the trial proceedings of the trial court and then gave completely a diagonally opposite order in which again he created several issues and confusion without even giving an order with reasoning. Any order which gives a stay in the pending proceedings of a trial should be well reasoned and it should be a speaking order. Whereas this order is of just 2 lines and it is again self-contradicting within 2 lines of what the judge wants to convey. One side he says admit, then he says hearing is expedited, then he says pending admission there shall be interim order in terms of prayer clause B, and he says add the petition in the final hearing board in the week commencing from 22nd November 2021. This is what is the order of Justice Sandeep Kashinath Shinde. And by doing so, the confusion what he has created is whether the writ petition got admitted or not, because soon after using the word admit, he is again saying pending admission, there shall be interim order. So again, while granting the interim order, he hasn't heard the case, which was a writ petition under section 482 of CRPC and under Article 227 of the Indian Constitution. And he defied the law, the well-laid process by the Supreme Court in pending process cases of trial courts. By doing so, he has indulged in unethical practice of delivering the judgment without looking into the file or without letting the respective counsels open their files and deliver their arguments. He has killed justice in the open court because he has delivered something in the open court and again he has passed something in terms of order subsequently. And he has made accused take rescue under final hearing date by wantedly prolonging the case and by listing the case under the final hearing matters, whereas the case was supposed to be heard at the admission stage itself and be disposed. Whereas he has extended the longevity of the final hearing date and gave in a way a relief to the accused. And now, when will be the final hearing? Only God knows. One may say this can be taken under SLP to Supreme Court, but Supreme Court, by looking at this kind of orders, generally don't interfere, because this judge, in a crooked manner, what he has done is he has put a date stating that the matter be added to the final hearing board starting on so and so date. Though he has passed this order in 2021 and now it is 2023, so far so the matter never came upon final hearing board. But if you go to Supreme Court, the Supreme Court says that since the matter is kept for final hearing, at this stage we don't want to interfere. This is the general order that you find in any SLP on the basis of the High Court orders. So no use for any litigant to go even to the Supreme Court. And the way this guy has passed the order without even providing any reasoning, or an order without reasoning, and an order which was not a speaking order, and by doing so, he also further contravened all the established norms of justice and in a way indulged again by triggering contempt of court. So when this kind of miscarriage of justice takes place, who will regulate and take action on this kind of judges who deliver very careless and reckless judgments? When justice gets butchered like this, who will save the affected parties in terms of timelines? When I researched, the same judge did a Pushpa Ganediwala in a POXO case where he has granted bail to a person who has indulged in a POXO case by stating that a 14-year-old is good enough to understand the consequences of a rape and let the accused go scot-free on a bail. And similarly, prior to his elevation as judge, the judge learned Justice Sandeep Kashinath Shinde happened to be the public prosecutor who argued on behalf of the victims in Salman Khan's hit and run case. And in that case, we all know Salman Khan walked out free of that case as evidences were found to be not sufficient to conclude the case, though everybody knows that people on the footpath died or affected due to the hit and run case by Salman Khan. Friends, this is what makes even people like us to feel that here justice is not done, but even the judges are also brazenly making the system so feel that it will not be done. What to say? This may be one of the kind of exceptions that I might have seen, or this may be the case with all. I don't know. But when I saw this, I was shattered completely, felt ashamed of myself and my legal background. Thank you very much for your patient hearing. Thank you.